We're going to get started here in just another 30 or 60 seconds, everyone. Just let more people stream in, and then we'll kick it off. Right. Welcome, everyone, to this office hours on all the legal aspects of buying a business. My name is Will Smith. I'm the host of the podcast Acquiring Minds. And attorneys James David Williams and Bill Barlow are going to host this session. James David and Bill are partners in Barlow and Williams, a practice that specializes in small business acquisitions. So they see tons of deals. They're really at the front lines of this market. And their focus is helping searchers like you all execute deals while, of course, protecting your downside. They also represent sellers, so they understand well both sides of the table, both sides of the transaction, all the psychology and levers of all parties involved. So I'm going to hand it over to them in just a sec, but a couple of housekeeping notes. The way we'll run today is, as last time, Bill and James David have a presentation to give, overcoming common deal sticking points. That's going to run for, call it 20 minutes. But the idea here is to leave tons of time for all of you to get your questions answered. So, and not just questions about the presentation, but really any legal questions related to buying a business. So to ask a question, use Zoom's Q&A function. You'll see a button in your Zoom window or app for that. And the session is being recorded. You'll receive a link to that recording by email in the coming days. And I'm going to put into the chat here links to James, David, and Bill's socials and email and contact information and website, as well as the presentation from last month, the office hours from last month. That presentation was the do's and don'ts of the LOI. So you can watch that recording at that link and contact Bill and James David at their email address and LinkedIn's there. That's it for housekeeping. Bill, James David, I turn it over to you guys.
All right. Thank you so much, Will. We appreciate being on here. I just want to set the stage for this conversation. Thanks so much, Will, for those words. The last time, in the last Acquiring Minds session, we talked about the LOI stage. So that's the process a lot of the searchers are in. You submit LOIs, you submit it to a lot of things. We are going to be going into a little bit more later in the process in this point. So last time we talked about everything you need to do in order to do an LOI. This time, the stage is you found a business, you're really excited about it, you've signed an LOI, but between signing that LOI and actually closing the transaction, there are a lot of issues which will come up. And sometimes those issues can be fatal to the deal and can blow an otherwise great deal apart. And sometimes you have to walk away, and sometimes there's a solution. So the point of this presentation is going to be to help you understand what are the issues that come up between that LOI signing and actually closing the transaction, and how do you overcome it. I originally thought I would title this How You Win It, but I don't think winning is really the right idea. It's more, how do you work together with the seller to come to a solution that allows both of you to get what you want and kind of move past some of these elements. All right. Well, I'm going to share my presentation at this point, and let me screen share. All right. That's our contact information. We're gonna
Gotcha.
start. And you can see it well, everybody can see it?
Yeah, looks great.
Great.
Okay, so we're going to start with diligence findings, because diligence findings often necessitate changes or retrade, although you probably don't want to use the word retrade, but alterations to the deal terms from what was in the LOI. Businesses in this sort of SMB space never have or very rarely have audited financials. And so as part of the financial process, especially if you're doing an SBA loan, although even if you're not, I recommend doing a QOE or a quality of earnings report on any business you're looking to buy. And as part of that, they will reconstruct profit and loss statements, balance sheets, income statements, etc. You will often find that the numbers that your QOE report shows don't match the numbers that the seller included in the information that was originally provided to you. If that happens, right, it can throw off your sort of pro forma modeling that you've done on the business and your analysis of the business going forward, et cetera. So that's probably the most common way that this happens, but financial diligence is not the only thing that could be an issue. There could also be operational diligence. You find out that there is a large customer contract that is about to churn, for example, or you find out that there are some, key employees that maybe are on the way out. Any of those things can be a real problem for you post-close. There are a few ways that this can be handled, though, that will keep the deal on track and account for the increased risk that you're taking on as a result of what you know now compared to what you knew then. For the sake of simplicity, I'll just treat it as focus on the financial diligence piece for this little quick discussion. So this is actually why we recommend, or it is so frequent that the finances don't match, that this is why we recommend putting a metric in the LOI of how you value the business as opposed to just a number, because if you have just a number, it's harder to have this conversation later. But if you had that metric and say the EBITDA was 10% less, then it's a lot easier to have that conversation. That said, a lot of sellers get very focused on the headline price, the purchase price, the headline number. And so they're not going to accept any reduction in purchase price. Now, obviously that can be your first point of attack, but sometimes that doesn't work. If that happens, that the seller is stuck on their number, this happens more if it's a round number, especially, then what you can do is shift the money, right? So potentially you shift a portion of the money from cash at close to a seller note. Or if you have money in a seller note, you make part of it contingent on certain performance metrics instead of just based on time. And those performance metrics could be anything. It could be employees staying, it could be contracts renewing, it could be, revenues. You do have more limits on what you can do with some of that if you're doing SBA financing, but there still can be ways around it. And then another thing you can do is effectively set a working capital target that's a little bit higher than maybe necessary, which is in some ways changing the price without changing the price in a real direct sense. But I'll go ahead and let Bill talk about working capital since that's the next portion.
All right.
Guys, can I hop in with a quick question?
Yeah, go ahead.
Of those tactics, James David, the seller note, and I guess we haven't talked about working capital yet, but are any of these more or less palatable to sellers? What kind of resistance should we expect? And, yeah.
Yeah, the most palatable tends to be making portion or all of the seller note forgivable. Because then you're not changing timing of payments, you're just sort of adding a condition. The next would be sort of increasing the seller note, because then you're shifting money from close to later, so that's a little bit less palatable. And then adjusting target working capital or changing the headline price would be sort of the least palatable. But the most palatable is probably getting fancier with the conditions around the seller note.
Okay, great. Thank you.
The next point we're going to talk about is working capital. This is something that I remember when I was on Wall Street and I was thinking, what are going to be the main things people argue about? And I was a little bit surprised that working capital was by far the thing that I found most private equity deals people haggling about. And I think the reason for it is because it's very much a split the pie situation, a dollar in your pocket or a dollar in the seller's pocket. Just to set the stage for a moment, what you will typically do in the LOI is you will say something like, this purchase price assumes a normalized level of working capital at the company. And so the idea is that if the company usually has $200,000 in receivables, $100,000 in payables, that at closing, you would get working capital that's net $100,000. But if there's a little bit of a change there, for instance, if there's suddenly more payables, then you will reduce the amount that you pay them at closing to compensate you for the fact that the working capital is less than what was expected. The issue can arise, what is that right number for working capital? That is something that is often up to the accountants. So make your accountants the bad guys. Hopefully you have accountants that are helping you. Make the accountants the bad guys. The other thing that can happen is just uncertainty, right? Even if everybody is sort of working in good faith, if you're buying a business where they do long projects, you know, that'll take 6 months to complete, then there's inherently uncertainty about how much has actually been completed, you know, compared to what the final costs are going to be. If you're dealing with a business with huge amounts of inventory, there's going to be sort of issues with valuing that. What I would say is this is something that is very deal specific, because some deals you'll just not need to deal with this at all. But if you have a deal where there's a lot of big projects, clarity is your friend. Create a nice template and then find a way in the purchase agreement to deal with what happens if you know, there's an estimation that goes off. Inventory. If there's a lot of inventory and you don't know whether you're going to sell all of it, buying it on consignment is often a great option. Having a working capital escrow, in larger deals that always happens. In smaller deals, it's a little bit less common. But if you are able to do that, that's a great thing, because you know, we can talk about other metrics, but the nice thing about a working capital escrow is that you will need that money right away. So if you don't get the working capital you need, you'll be able to get that money from escrow immediately and be able to continue to operate the business. So those are the common things, and this is where having a great accountant and also having attorneys that know what the sort of mechanics of working capital and all that stuff go in can be really helpful. I'll also say this is very commonly an area where you will win or lose $100,000 easily, $200,000 easily, and also potentially set yourself up for failure if you buy the business and you suddenly need capital on day one. Like, this is a pretty important point. So I would recommend spending some time with this.
Bill, we often hear about working capital pegs. Is that what we're talking about here?
Yes. Yeah, exactly.
And maybe now, or we can return to it, but can we maybe just get into the mechanics of it, just a little bit more granular detail to really understand it whenever you think appropriate, either now or after the presentation?
I'll do it. I'll do it an overview now, and then we can come back to it if people have questions. So what will happen is you will negotiate about what that working capital peg should be. So as in the previous example, let's say you say $100,000 is your net working capital peg. What will happen is before the closing, the seller will come to you with an estimate as to what the working capital actually is. So let's say that they come to you at closing and they say, okay, our working capital peg is $100,000 net, but right now the net working capital is $50,000. So that's a deficit of $50,000. Then at closing, what you would do is you would reduce your closing purchase price by that deficit by $50,000. And instead of paying that to the seller, you're going to fund that into the business so that you can continue to operate in the ordinary course. Then what will happen is you'll have a period, typically 90 days, where you'll go back and you'll look at that estimate and say, was that correct? And in the event, for instance, that there actually wasn't 50,000, there was only 25,000, then that's a difference. So the seller overestimated the net working capital, and so you have to find a way to do that. In a deal with an escrow, you just take that amount out of escrow and you give seller the rest. Otherwise, you might be dealing with adjustments to the seller note. That's more stuff we can go into later. If there is a dispute, you typically have an independent third party come in to help resolve that dispute. So hopefully, I know that was kind of short, but hopefully that gives you a little bit of sense of the mechanics. That right before close, the seller will give you an estimate. You'll take a look at it, and then you will, after closing, basically make sure that that estimate was accurate as of the closing. The other thing I'll point out is that in SBA finance deals, you can only have working capital adjustments that go in favor of the buyer. So that can become a sticking point because the seller is like, oh, I delivered extra working capital to you. Do I get more money? And typically in an SBA deal, the answer to that question is no, because the SBA has sort of underwritten a specific amount and they can't go above that amount. So dealing with that is another point where you know you have to kind of engage counsel and kind of get to something that both sides are comfortable with.
Bill, a couple follow-ups here. This is fantastic. That point about the SBA only doing working capital true-ups in the buyer's favor, that would suggest that sellers are incentivized to underestimate working capital as a rule. And so you, buyer, are going to pretty likely to find yourself in a position where, oh, seller, you underestimated the working capital that you left in the business. I need more. Let me go get it from escrow. What does that look like? You said if there's a disagreement, you bring in counsel, but what is it? Is it sending an email? I mean, when I want to go get an extra 25 grand from escrow because the seller underestimated the working capital that he or she left in the business, how do I actually get my hands on that 25,000?
Yeah. So if you have an escrow, then what you do is you email, and you have an email that basically says, you know, my accountants have reviewed, you know, this was the estimate at closing, you know, based on our post-closing review, this is the new estimate. And so we suggest that we'll pull that difference from our escrow and refund you the rest, and basically just make that your proposal and see if they push back on it. Right.
Okay.
Yeah.
Okay. Yeah, that's great. And then just one other thing. So probably the biggest negotiation point here will be what the peg is. So the buyer's accountants and quality of earnings folks come up with this peg, and then that's something their side is the seller's likely to say, no, it's whatever. So that's really the key number often when it comes to working capital, is what the peg is.
Yes.
Yeah.
That's the big fight.
Yeah. Okay. Great. Thank you.
All right.
Right. So the next issues that we'll just sort of give an overview is indemnification. And so indemnification is the process where, right, in the purchase agreement, the seller is going to be making a number of representations about the business, right? That they own all the assets, that they paid their taxes, that certain contracts are good, etc. And if it turns out that one or more of those statements wasn't true as of the time of closing, you have what's called an indemnification claim, which is a way for you to grab money or to be compensated for that loss of value based on the misrepresentation. Just as a matter of practicalities, it becomes much harder to get money back once you have paid that money to the seller. And so because of that, we want to have, you just want to make sure that certain things are handled properly. This also links with sort of the diligence findings issues, because if you do find something in diligence, you could have a special indemnification just for that special representation. That can be a great way to do it and sort of link it into the seller note. One thing, just and here really, don't expect any of you as searchers to get into really all of the weeds here at this. The indemnification mechanics really is something that you need to just work through with counsel. And ultimately, I just encourage you to make sure you understand what your attorney is saying the agreement means, and just have your attorney walk through different scenarios, because there can be a lot of different things. You'll find that there's different, some representations will last for 12 months, others will last through an entire statute of limitations period. Like, what does that mean? Right? How does that impact your ability to get money? There are things like there can be caps on indemnification for different things. There could be, deductibles or other limits, right? It just gets complicated. But the biggest thing I would say to you as an audience is just know that this gets complicated. It's very tedious, but it's very much worth it, because if something goes wrong post-closing, this is how it gets resolved. And so, work with an attorney who's done this a lot before, and make sure that you're comfortable with what you're hearing when you walk through it with your attorney. We have found that a lot of people have potentially never even heard of indemnification before they go through the process of buying a business. And so just make sure that you understand how it works and that you're comfortable with it, because it's how risk gets handled in the transaction.
James David, given that this is going to be, many people will not have heard of this concept, as you said, before entering into this process, and that it is complex and tedious and so on. Is this something where you just lean on your attorney to negotiate on your behalf? And like, I guess you said, just like make sure you understand what the attorney's saying, but really this is a case where we're delegating all thinking to the attorneys on this one?
Most thinking. We do have clients sometimes where they insist on certain things. There's certain things matter more for some reason. I don't necessarily have examples of that, but certain of the representations, it's just something about it. Like, if this is wrong, like, that just should be more. So sometimes people are odd, but often, yeah, no, this is for the attorneys. And it really is just about making sure you understand all the different mechanics. And it's good to ask questions. Some attorneys will get annoyed by me saying that, but ask your attorneys questions about what happens if this breaks, what happens if this is wrong, what happens if this is wrong at this time, right? Ask those sort of questions, because when you're buying these businesses, right, this is a huge financial commitment. So know what you're signing up for.
One thing also I would just like to add is that this is often an area where if the seller has a counsel that is inexperienced or intransigent and stubborn, it can create real problems, because you will propose something that is totally market, and oftentimes inexperienced sellers' counsels will propose something that is completely off market and basically want to not get any, provide any indemnification for any reason. And so the conversations can be difficult, because you can say, like, well, the seller is listening to this lawyer that's whispering in their ear and saying all these terrible things are going to happen with the deal. How do we deal with that? Like, what the real risks are? And so this is very commonly an area where if the seller does have inexperienced counsel, you will find yourself in fights that you really shouldn't be having. And it's very frustrating, but that can be part of the process.
Mm.
So sometimes I'll just throw this out. There have been times where, as buyer's counsel, we have been asked, the seller asked the buyer for a recommendation for counsel. And it's kind of a weird situation. But if you find yourself in that situation, oftentimes your counsel will be able to recommend somebody else, because there are plenty of law firms that do this regularly. And as long as you have another law firm on the other side that also does this regularly, this process should be very smooth. It's only if you get an inexperienced person where you tend to see this really, gunk up.
Right.
The final issue we thought we would just go over as part of our presentation is non-competes. Now, I will say that for probably 80% of the businesses, this is not that much of an issue. Not because it's not important to have a non-compete, but because the seller is retiring and couldn't care less, is not going to do anything, whatever, write in whatever you want, I'm out. But there are times when the seller, especially if the seller is younger and is going to be actively starting a new business or doing something like that, this can be extremely important. And especially if it's sort of an adjacent business to the one that you're currently doing, this can be very important. Where this tends to become an issue when it becomes an issue is usually about the scope of what's covered. So the seller is saying, hey, I'll just give an example. A seller is selling a marketing agency, and the seller says, well, does that mean that I can't do a job in marketing anywhere in the world? Right? Like that destroys my livelihood. I can't do anything. And so, what you end up doing here is you generally try to find something where the scope is more limited. I mean, you start with broad scope, broad time, broad location stuff, as broad as you want. But usually the thing you care more about is the time and geographic limitation. And you can usually make the scope a little bit more tailored to the particular business, so that the seller feels like they're not just trapped and can't do anything in their career. So.
Now, this is one of those things that, as Bill said, right, it doesn't matter most of the time, but when it does matter, it can be the most important thing for the seller after the price. So,
Yeah.
And it ends up being often a principal to principal conversation about, hey, this is what I'm buying, this is what I'm intending to protect, right? You need to, and there is some trust involved, right? Non-competes are not the easiest things to enforce. Though I will say, despite some of the new rules that are currently being challenged, right, non-competes on the sale of a business are still enforceable and will continue to be. But you really don't want to have to end up in court over this, right? So, it's one of those things where trust matters between the buyer and the seller, and hopefully you've built the rapport throughout the entire, right, even pre-LOI, building rapport. Right, and having some of these conversations is why you build that rapport, because you're going to rely on that in order to get the deal over the line. So,
yep. James David, why is this one so sensitive, and why does it go principal to principal as opposed to?
Yeah, I mean, this one goes principal to principal more often because people understand it. It's more intuitive. Than say indemnification is. And the lawyers are just gonna go back and forth bickering, but it's like, what actually matters, and what does the seller, what does the seller actually plan to do? And that's sort of why we say, right, lead with the maximalist proposal, because then the seller is going to come back and sort of reveal to you like what they actually want, if they want to do you know, if they're not retiring, right? Say, well, I was doing this business, but now I want to do this business. It's like, okay, great, we'll carve that out, right? We can exclude that. Or, you know, the seller has multiple businesses sometimes, and they can kind of overlap a little bit, right? Well, if I sell this one, does that mean I can't work in my other business again? Well, no, but let's get in and let's actually detail it out. So it's in those type of scenarios where it really matters, and that ultimately is a principal to principal trust sort of conversation.
And do you ever, is this point in the negotiation ever one you see that surfaces bad intentions by the seller, or that would have already happened, where like the seller is basically kind of wants to at least have the option of competing again?
Yeah, I
Or is
mean,
that probably not, they wouldn't be so transparent or so obvious about
yeah, I mean, it doesn't come up early, right? Because in the LOI stage with a non-compete, you're saying there will be a standard non-compete usually, right? Sometimes people will define a time length, but usually not. There have been a few times where we've gotten a red line back and been a little concerned from a seller. And it's like, oh, well, let's look into this more. Right. It doesn't happen often, but yeah, it can happen, especially if there's a sort of, if there's something weird. We had one time where they cut the mileage down just enough that there was a decent sized metro area that was now excluded from the non-compete. So there can be things. It doesn't happen often, but sure, anything can happen.
The other thing that I say is a little bit of, probably not a red flag, but at least a yellow flag, is that if they're suddenly fighting you very hard on the time, right? So it's like only 3 years, only 3 years. And if you've narrowed the scope enough so that it's effectively just what's really competitive with the business, then all of a sudden I ask the question, which is why do you care so much about being able to jump back in 3 years instead of 5, right? Like that sounds like you're taking a nice little vacation for yourself and then going back to business. So, that where they push back can be a little bit of a, but why, moment. Well, that's kind of, in terms of the formal presentation, that was sort of the points that we had. We'll be happy to talk a little bit more about our law firm and other stuff sort of as we wrap up, or if we want to do it now, but we're also happy to circle back and go through some of the points that were discussed earlier. I'll just give the elevator pitch for us. I mean, we do these type of deals all the time. Our background is James David and I, we were both at Harvard together. That's where we met. I went to work for Wall Street. He was a DC litigator. We work on a flat fee basis. And we find that really works to help searchers know what the costs are, and be able to successfully execute their transaction. So feel free to reach out to us at any time. Our website, our email is right there on the screen. But we're happy to, we'll probably say that again at the end, but we're happy to circle back and talk about any of these things if there's been any questions that come in.
Great. Well, fantastic presentation, guys. And we do have a bunch of questions. Just to remind the audience too, if you see in the chat here, just above that, you'll see Bill and James David's contact information, LinkedIn and stuff. So you can just click the email if you want to reach out to one of them, and their webinar from last time, webinar and office hours from last time. James David, on was it the indemnification? You said something that I've heard said a lot, but it's always glossed over, and I'd like to have an attorney say it explicitly. This thing about what is the cliche, possession is 9/10 of the law or something. Point being, and this is just, I feel like, a good business learning and principle, like better to always have your hands on the cash rather than try to claw it back. sort of thing in all life, really. But but particularly in our world as well, or in these negotiations. So I hear that sprinkled all over all the time. Can you say more about that kind of principle at work?
Yeah. So possession is 9/10 of the law, right? If you have the money, you can spend the money, right? These indemnification sections, it's this big long article in a purchase agreement, and it lays out this whole process that you have to go through, right? And that can vary, but it could be litigation, it could be arbitration, there could be, just a back and forth, but there's a whole process you have to go through. And that could take months or potentially years, right? Depending on how involved it is and the procedures that are laid out. And so if you have to wait months or years before you get that money, that's obviously that's a big problem if you need that money, to pay payroll in 2 months. So that's a little apocalyptic, but that's why we say that, right? Because it takes time to pursue a formal indemnification claim. And so because of that, if you're the buyer, you want to control the money, right? And if you're the seller, right, you want more money up front, right? That's the push and pull of these negotiations.
And I would say this is where the set off right is so important, because it's a lot easier for you not to pay money that's owed under a seller note than for you to ask them to pay you based on the claim. So
yeah, great, guys. Okay, a lot of questions. So, and we'll just be jumping around because people's questions will be on non-competes. Family members, let's say family members who are not actually in the business, in sellers, family members, but who are not actually in the business, starting a competing business. Can you say, neither the seller nor anyone in their nuclear family nor their first cousin can start a competing business? Sort of that. What do you say to a family?
that is very difficult to put in. You basically don't do that. It is a diligence item, right? If they are actually in the business, there are things you can do. That is more common, right? You have a son or a daughter or a cousin, whatever, that's in the business. There are workarounds. There are ways of getting them on a non-compete. Somebody who is not in the business, not right now, stopping them, it's just not something that's feasible. First of all, because they're not a party to the contract. So typically in a non-compete, if somebody's violating it, you're not going after damages. You're getting an injunction to basically say, stop it, right? You can't do that to that other party because they haven't agreed to this non-compete, right? So you would just have a damages claim against the seller, even if you could, but I don't think I've ever seen a situation where it was. And if I was a seller, I would very, very strongly resist that.
Yeah, where it is an issue and a diligence matter is if there's a child in the business, most often, but when there's family members who are working in the business but don't own the business, then it can be more of a concern, and there are ways of handling it. Potentially, we discussed that in the last webinar. I don't remember, but because you can do it through some of the employment agreements, through potentially giving them a little bit of ownership in the business. There's a few different mechanisms that can be considered there, but that is a risk, right? Because if the son or daughter and mom and dad or mom just got a bunch of money, I say, well, there's going to be some temptation there to like, oh, I can just go out on my own, take the relationships my parents had and start my own. Does that would that violate a non-compete? Maybe you could litigate it, but you really don't want to have to, because if you have to litigate something like this, something's already gone wrong.
Yeah.
The other thing I will just add briefly about this is that, no, I sort of lost my train of thought for a second, but
Family members, non-competes.
yeah. I think that one of the questions you want to ask yourself is if the business itself is so relationship dependent that the family member could grab all those relationships, start a business tomorrow with somebody that hasn't been into business at all and immediately port it over, then that's almost an operational risk question, you know?
Great point.
Because,
Great point.
you know, yeah. So that might be an issue, not legally, but just in general.
Yeah.
So.
Great. Question from Gregory. Securing or guaranteeing the seller note. Can you provide color on sticking points where the seller insists on getting a second lien or personal guarantee on the business if you default on the seller note? Have you seen win-wins where the buyer gets indemnification or forgivable notes in exchange for giving the guarantee?
I mean, typically those aren't necessarily tied together. I would say we see secured notes happen. That can mess up some bank financing depending on what you want to do. I mean, typically you can do it, but obviously they'll be junior to the the bank, which if you're using SBA loans means that they're in a very junior position. But it is common. I think personal guarantees will, as a buyer, I obviously try and resist it because if you're at the point where you have already breached your seller note, that probably means that the business has gone south. And so, you know, you really don't want to be putting yourself in a situation. You're all signing up for these personal guarantees. You don't want to be in a situation where you have to do even more of that. I have sometimes had buyers be like, I'm already personally guaranteed to the hilt. What's one more? Just add it on. But, you know, we advise them of those risks, but sometimes they're willing to do that. I wouldn't say that those things are always necessarily traded against in the same way, but it is true that sometimes sellers will want a personal guarantee, and we always resist it. I have seen a couple times where buyers kind of be cowboys. So I can't say I recommended it. We didn't.
No, I had one, I think it was last summer that closed where the seller this was intransigent seller counsel is who I blamed for it, but insisted on it, was going to walk away from the deal without it. And ultimately they ended up, it was split into two notes. So they did a PG on one of the two notes, one of the two seller notes. And that was enough. Again, right, I walked through, it was like, this is the additional risk that you're taking on, or this is the scenario where it matters. It's a pretty small band, really, if you're already doing the SBA personal guarantee, right? Because that's the first priority. So, right, as Bill said, like some people are just like, what's another one? But yeah, in that one, for whatever reason, they ended up being a personal guarantee on one and not the other of the seller notes, and that was enough to get it done. So, you know, it's just one of those things that could get weird, right? Hopefully it doesn't to you.
Yeah.
Although I have to say, guys, this thing about this buyers who are just like, well, I'm already so guaranteed to my eyes. What's another much smaller personal guarantee that's junior? I mean, I feel like none of us want to recommend people just have guaranteed all their stuff. So it's hard to recommend this in good conscience. On the other hand, it is like, I think what you're saying, James David, is the situation in which that would become relevant is so remote. If the seller really wants it, it seems like maybe it's one of these where you can give it because it's really at the margins for you anyway, and use it as a pretty strong negotiating thing. It's like, well, seller, if I'm going to give this to you, you got to give me all this other stuff. You know, it almost seems like,
yeah, I mean, that's what
as a negotiating,
that's what happened in that transaction. And
Yeah.
it was the last thing that got resolved before closing.
One thing I will just say as a note of caution is to say that the willingness of your lender to actually go after the personal guarantee may be different than the willingness of a seller to go after a personal guarantee. So, you know, the lender might be like, look, we know these things happen. Realistically, I'm not gonna, you know, do this. You could have a seller that's like, that is my money, that is my retirement. I am, you know, scorched earth. And so that's part of why it's important, even if you're very junior, you could have that issue, if that makes sense.
Yeah, it's a great point. Great point. Yeah, it's one of these where we all often hear about the PG and banks. Like, the bank doesn't really want to foreclose on your business. What are they going to do with your business? They really want to make things work. And a seller's motivations might be very different than that. Scorched earth, as you said.
Yeah,
And this
that
is
is that.
that may be the last chunk of change they're ever going to earn in their lives. So they mean business.
Yeah, that is the scenario where it matters, right? And you know, somebody asked a question in here about pausing payments if the for the seller note, and yes, you can write in, right? Because if you're not hitting certain debt service coverage ratios on the SBA loan, they won't allow payments on a seller note, right? So you can write that sort of thing into this so that you don't have a foot fault technicality thing. But yeah, the scenario, but there is the scenario where that we just described where the seller is more aggressive than the lender. So
Great.
advice to buyers, don't lead with this as an offer.
Forgivable seller notes question. In your experience, what works best to tie the forgivable seller note to? I'm dealing with an offer and just had a discussion with the broker about this to, quote, better define the forgivable piece. So I guess the broker wanted it to be tied to more tightly to very specific metrics, and it was too broad, I guess, initially.
Yeah, I mean, I don't usually see it tied in an LOI necessarily, but you know, some people could. And the advice in some sense hinges on whether it's an SBA transaction or not. You have a lot less flexibility. If it's an SBA deal, it has to be based on a historical performance metric, something like if the revenues fall below 90% of the revenues in the 12 months prior to close, right? You have to have something like that. Whereas if you're not an SBA land, you could have something like, if this particular contract doesn't renew, then we're reducing it by this, right? So you have more flexibility if you're outside of SBA land. If we're on the sell side, we want it to be tied to revenues and not profits, for example, because profits, there can be a little bit more wiggle room in how that gets calculated. So don't, if you're the buyer, maybe you want it to be profits or EBITDA or SDE or, whatever. But if I'm on the sell side, I'm going to push back against that because that's easier to game. But yeah, so the biggest, most common ones are going to be revenue targets. And then, if you're not an SBA or, some sort of financial metric, and then if you're not an SBA land, if there is something unique, like employees sticking around, right? That can be a thing. You can have special one-off things but those are deal specific. So
we talked at the top about diligence findings, financial diligence findings, and how in the LOI you kind of glossed over it because we probably covered it last time, but let's cover it again because it's a good one. The purchase price that you put in your LOI to your seller, is it an absolute number, $5 million, or is it a multiple? So a point being, if it's an absolute number, the danger there and almost the certainty there is that the seller is going to become married to that number. And if you try to then retrade at $4.5 million, they're really not going to like it because $5 million is seared in their brains. But if it's a multiple, then they're less tied to a financial number, to a dollar amount, And also just gives you, it allows you to, if the SDE comes back much less, then you're not actually retrading anything. You're just paying a lower, it's already what's been agreed to in the LOI.
Yeah.
But sorry, James, excuse my preamble. Question is that the best practice? Is that basically always do that? Always make your LOI purchase price offer a metric as opposed to an absolute number? Say more about all of that, please.
Yeah, most often we will have our clients do both. Right, this is the purchase price, assuming this metric. Because if you don't put a purchase price and just put a multiple, then because when a seller looks at an LOI, the first thing they're looking for is the purchase price. So you don't want to confuse people. And in some ways it's the most common presentation is, the purchase price is this, assuming, and that is based on this multiple of this metric. Right, it's a little bit easier if it's not a round number to have the conversations later. If it is a round number, and when I say round number, sort of million, even half million sort of levels, even if it was like 1.2, 1.4, right, that's a lot, seems vaguer than 1.5. People can get stuck. I don't know. Some of the funniest ones are when they get very, very specific to like the penny, or to a unique dollar. There's some psychology around that potentially being a negotiation tactic. I don't see it very often with businesses, but there can be reasons why some people might do that. But anyway, that's a digression. The main answer though is it's this price assuming this multiple of this metric, and just put both in the LOI.
Okay. Great. Question: how do you deal with the situation where the seller insists on using a neutral transactional attorney with fees shared equally to prepare the first draft of the purchase agreement and prepare the closing docs? Is this something you can get around if this is the only element getting in the way of the deal?
So
I guess,
I don't know that I've ever encountered a seller who wanted to do this. There are brokers who will do this, or will ask for this at times.
Sorry to interrupt, James David. Could you maybe put into your own words what they're talking about here?
So what this would be, and it's not even allowed in many states. There's only certain states where you can have this, but it's effectively an attorney who represents neither party, but represents the transaction itself. And so basically just to make sure that, everything is in place for the transaction to happen, the escrow agreements are all lined up, etc. As an attorney, I can't recommend doing this ever, because having that sort of thing, like that person, right, they represent the transaction. They don't represent either you as the buyer or the seller. And so like, what are they even doing? Sometimes this is done by brokers to try to ram things through too quickly. That can happen sometimes in these sorts of scenarios. Whatever you do, you need your own counsel. And the seller needs their own counsel, right? If you're doing a transaction of any size. Bill, you're coming in. I can see the wheels turning. So.
Yeah, well, the only reason I was going to say is that number one is, I think that in general, when this is proposed, when it's proposed by the broker, that is almost always much more seller friendly of a document than you would normally get. Brokers tend to offer much more seller friendly documents as a matter of course. So if you just accept, yes, we'll use the lawyer who is quote unquote, neutral, you're effectively often getting a lawyer that is giving documents that essentially are sell side, very, very friendly documents. So if the entire deal hinges on this, what I would say is, they can prepare the first draft if you love the deal in every other way, but you still need to have a buyer attorney to look it over, because they could just completely give away the farm to the seller, and often do, frankly. So, if that's a sticking point, but you just need them to know, like, you are going to have your counsel reviewing this, because otherwise you're effectively signing the most seller friendly document you possibly could.
Mm-hmm.
And only
Mhm.
brokers that are very inexperienced would push back against that. Frankly, usually inexperienced brokers are the ones that would ask for this in the first place.
Mm-hmm. Great.
This is also, by the way, something we've been asked to do a lot of times, and we always refuse because we just don't feel like it's realistic. So.
Well, in this particular case, the asker, the questioner, writes as a follow-up that independent attorney review is allowed, and the deal is subject to agreement on that by both parties. So for whatever reason, they're insisting, I guess, that this neutral attorney prepare all the docs, but then it's okay for each party to then have their own attorney's review.
Yeah. One of the problems is that you're effectively getting the very seller friendly draft, and you're going to look like the bad guy when you come in and inevitably have to provide some red lines. Like, why are you doing this? This was neutral. Well, it never really was neutral. So
yeah, that's great. Great point. In all negotiation, often, or the one authoring the document, if they can just put so many things in there that are to their favor, and it just puts you in the uncomfortable position of having all these issues as the first round, all these red lines, and that is a weaker stance in the negotiation.
Yeah, and the normal flow of these transactions is that the buyer drafts the documents. Right? That's the norm.
Guys, going back to the having in the LOI, the offer being calculated based on a multiple that's also in the LOI. What happens while the LOI is agreed to, business surges, does really well while in diligence, and then can the seller, doesn't that give seller more strength to try to themselves retrade?
In theory, in practice, we do not generally see sellers. I don't think that I've seen a seller try to up price in retrade. Often what will happen is they will maybe do other things. Kind of, we went through on all these other tactics, right? They can do the tactics in reverse, but trying to retrade price, unless there's been something very materially significant happen, such that the deal just doesn't make sense anymore. If it's just going well, then they don't. I'll give you one example. One example we had is actually, it's tied to working capital, because the deal, like, they started doing really well, and they actually started getting a much more working capital in, because they were getting much more accounts receivable. They were getting much more orders, right? And so, we were sell side in that deal. The buyer was like, hey, I'm not going to pay for all this, working capital. And the seller was like, yes, you will, because you should be happy about how much extra business I'm doing, and so there was discussions about changing the working capital peg and, that type of stuff, because anyway.
Great. Question on working capital peg and the works in progress. So, this is going to be relevant to kind of a construction-y business, of which there are many that transact. let's say, what if there are some projects that have a long cycle to completion, these works in progress, and a long cycle to completion, and you were talking earlier about the percentage completion being calculated and agreed to. What if you get that wrong? What if you agree that a project is 70% done with the seller? Turns out it was 30% done. How do you deal with that? It must be very hard to predict these things 100% accurately.
Yeah, and this is where sometimes if you have a holdback, sometimes you might have a holdback for 6 months or a year if it's big enough, just so that you could be like, look, if you know, we'll disperse this to you, but this is basically just like you would have a working capital escrow that usually only runs 90 days, because usually within 90 days you have a very good idea of what the real working capital was. If it takes a year, you could potentially lengthen that for a year. The other thing that's commonly done is to do some type of, again, forgivableness in the seller note. The only problem with that is that if you actually need that money right now, like getting forgiveness for something you're going to pay in over 10 years is not the same thing as having the cash to pay the workers that are doing that deal. So that's why that element's also important.
A few just questions, but let me actually, before I do more questions. So we're at the hour, we're beyond the hour. I have a couple more questions here. Audience, if you have a burning question, now would be the time, because we're going to wrap up here in just a minute. Don't want to keep people super long. So ask your question now. I got a couple here, and then we'll let you guys just put your contact information slide up and wrap up. On like earlier stage. So the question is, are there any warning signs that a company's more likely to have a problem come up in diligence? So that you just, yeah, I mean, are there trends there? Maybe the smaller the company, the more likely in particular industries?
You should just always assume that the financials are going to be off. Just assume it. I'm pleasantly surprised when it doesn't happen. But just sort of always assume that the financials are going to be off by 20% when you're doing your modeling, and hopefully you can be pleasantly surprised. And that's just the smaller the better, or the smaller the business, the more likely that is. And it's not that people do anything malicious, right? Most of the time it's not that, but it can be. Right, a business has been operating on cash accounting, and you have to, you're running your models on accrual, right? That's probably the most common one. And when you do that, things just get wonky. So just know that's always a possibility, but that's not a particular, and that's not industry specific at all. So
I think the other thing I would say is, one, sometimes certain brokers are better than others. And it's tough because most times as searchers, you might not know that. Sometimes the lawyers do, because we do enough deals. So you can talk with us if it's especially in our expertise. So different brokers have different levels of quality control. And then the second thing I would say in terms of industry is, I think there are just certain industries where the information is a lot more easily accessible. So, some SaaS deals that we do, software as a service, they're getting the Stripe income, you can see it come in, and the diligence process for that is a lot cleaner. Compare that to deals where, and I'm just kind of making something up, you're doing a hair salon and people are paying in cash, and a lot of like whatever, like different deals have different amounts of checking and just different cash flows, or invoices paid on 30 days or net 60. So that kind of changes it as well.
Great. So the question is, what are the common diligence issues that lead to a lowering of price? And I assume there the questioner means not financial diligence, but maybe other diligence items. And so is there anything that you can do prior to the LOI stage to predict those or to figure those out?
I would say that this is where the operational diligence really comes in. So key employee risk, for instance,
Yeah.
can be a big one. Going to the site, if it's possible, if it's allowed, meeting them in person. And most of the time, frankly, this is a financial diligence issue. It can also be, though, the other one is probably related to customer contracts and relationships, right? And a lot of that is also kind of knowing your industry and how relationship driven this one is. I mean, I'll just give an example that was recent. We had a client that was looking to purchase a business. It was a professional services business, and there was a lot of the seller came from a particular community, and a lot of the clients also came from a particular community which had a certain language background, right? Well, obviously you might not be able to carry that forward. So just doing a little bit of diligence and thinking, oh, is that something I should ask the seller about in the LOI stage, so that I don't go to the other side of it and realize, oh, there's much more customer risk and client risk than I initially anticipated. So I would say this is where operational diligence really kind of comes in, very key.
And is there a bright line between doing operational diligence as much as possible pre-LOI versus post-LOI?
You're going to get more access post LOI.
Yeah, of course.
And pre LOI, you're right. You really only have the SIM. Depending on the business, you could go through or pay someone. But even then, people do this post LOI, right? But sort of, go through the customer journey. Sometimes people will do that.
Yeah.
So depending on the business, you may be able to do something like that. But no, I mean, you're not going to see a lot of things until post LOI.
One thing I would additionally say is it depends on how quickly it's come to market. So if it's a deal that's been on the market for 4 months or something, then you probably have more of an ability to get access and due diligence pre-LOI, because it's not like it's about to transact. If it's a business that came onto the market and it's the type of business that every searcher is going to salivate over, then you're just not going to have enough time, because it's going to become very competitive very quickly. So you're just going to have to get in an LOI and then realize that you'll have to deal with those issues afterwards, because otherwise you're going to lose the opportunity.
Yeah. Great. Last question, guys. Some brokers mandate putting in a working capital number, absolute number, in the LOI versus a formula. Or waiting for the Q of E to get the working capital peg. How do you recommend handling that?
Yeah, we say in the LOIs or something like the business will be delivered with a normalized level of working capital. Basically put it off till after the Q of E. It's not a good idea to put a number in the LOI, because that gives the seller and the broker something to latch onto, because in all likelihood you're underestimating it. And if you put the number, then you're stuck. It's like, well, this is what you said you wanted. And if it turns out you actually needed double that, that's a problem for you. So it's better to not put the number at all.
Sometimes when they very insist on putting a number, what we'll say is normalized level of net working capital, which initial diligence says is estimated to be X. Again, we don't like doing that because you're still getting the anchoring problem, but at least there, just like with putting the purchase price and putting the estimate down, you're signaling that if something comes up in financial due diligence, that number could be subject to change.
Well, it seems like a pretty unreasonable demand, because working capital is so difficult to calculate even when you have access to all the books. So having so little information pre-LOI, putting in a working capital number just seems like sort of thing.
Yeah, and that's also one of those things, like LOIs are non-binding, and that is certainly something you should not feel bad about retrading. Like there's more sensitivity about retrading price, but do not feel bad about retrading working capital number if you are strong-armed into it, because there's no way you could have known.
Yeah. Fantastic, guys. Let's let everybody go. We're 11 minutes over. Great. Thank you for that last slide. Any closing thoughts, or should I just wrap us up, gentlemen?
Well, feel free to reach out to us. We really enjoy working with you guys, and so hopefully we'll talk to some of you guys soon. So
great. Well, fantastic office hours. Again, just really educational. I'm sure we're all learning a ton here. Audience, you will get a link to this recording and the slides in the coming days. And James, David, and Bill will be back next month for a third office hours with same format where they choose a presentation topic, and then we'll spend a lot of time answering your questions. So listen to the pod and be watching for that. And with that, this concludes the webinar. Thank you, everyone, for coming. Thank you, James, David, and Bill, of course. Great job, guys.
thank you.